Take her into custody. Did you just use the F word in front of these kids and in front of me? Good morning, welcome to Conneaut Municipal Court. My name is Nick Irochi. I'm the judge, and this is your initial appearance on traffic-related charges that have been filed against you. As you can tell, we have a number of students here from our Conneaut Middle School. They're here to observe proceedings. They're here every Tuesday morning for most of the year. They're here as part of the 36th year of the My Day in Court program, the longest running program.
Buckle up, guys. Today we're going to witness a courtroom moment that goes off the rails instantly. A defendant lets a profanity slip in front of a room full of middle school students, stopping the judge mid-sentence. What was supposed to be a routine introduction turns into a tense standoff, setting the tone for everything that follows in this hearing.
Running program in the state of Ohio, and they're here to observe only. This program is sponsored by our local Conneaut Rotary Club. The court is now calling State of Ohio and City of Conneaut versus Shannon L. Sullivan, case number 22 TRD 702. Good morning. The court will note that Ms. Sullivan is here. This alleged incident took place on November 1st of 2022. And Ms. Sullivan was given a arraignment date. She failed to appear. They issued a warrant for her arrest. As a result of her failure to appear on November 23rd, 2022, a warrant has been issued and has remained outstanding.
From here, the hearing shifts into formal procedure. The judge calls the case and lays out the timeline, noting that Sullivan missed her original court date and has had an active warrant for years. As he recounts a long delay and her decision to finally turn herself in, the tension rises. This isn't just a traffic case anymore. It's a problem that has been ignored far too long.
Outstanding since that date, and a warrant block has also been issued. Ms. Sullivan contacted the clerk's office and is turning herself in on the warrant. Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. You understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022.
The judge moves to the charges, outlining the real weight behind them. A suspension, possible jail time, fines, and the unresolved insurance requirement. What should be simple becomes complicated when he questions why the officer marked a crucial box as not applicable. It's clear Sullivan isn't fully grasping the stakes, and the judge's growing concern hints that this hearing may not stay calm for long.
2022. If you're not able to provide this court proof of insurance in the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids. And then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir,
Get out of here. The court is on the record in City of Pontiac and State of Ohio versus Shannon L. Sullivan, case number 22 TRD 702.
This is a breaking point. The judge stops cold after hearing another profanity from Sullivan and immediately orders her into custody. The courtroom becomes silent as he reprimands her for swearing in front of students and tells her to think about her behavior from a jail cell. It's a sharp escalation, turning an administrative hearing into a moment of raw authority and consequence.
702, the court was in the process of arraigning Ms. Sullivan earlier today when Ms. Sullivan, during the hearing, used a profanity. The record will reflect that there were students here from the Conway Middle School here to observe through my day in court program at the time. I had Ms. Sullivan taken into custody. She is now appearing at this hearing by way of video, and I will continue this hearing that had already taken place or was in the process of taking place with her appearing from the Conneaut City Jail. So Ms. Sullivan, I'm going to just pick up where we left off. I think I explained to you the maximum potential penalties you could face with respect to each of these charges, and I think things went south when I was trying to explain to you that if you are unable to provide proof of insurance on the vehicle that you were driving on November 1st, 2022 to the court and are convicted of either or both of these charges, that you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you remember me telling you that?
yes.
And then you had a question what that means. So do you understand what that means, or you need me to explain
I
it?
had a question. I was actually asking because you used another word,
The
and
officer...
I didn't understand what that word meant because I had never heard of it. So
The officer checked the box on the ticket that said not applicable.
Once she's brought back on video from the jail, the judge resumes the hearing with a noticeably firmer tone. He retraces the insurance issue and the earlier misunderstanding, making sure the record is clear. Sullivan seems calmer now, but the judge continues methodically, aware that the earlier outburst already changed the direction of this case. The atmosphere is tense but controlled.
And I indicated, I don't know why the officer did that, because it's alleged you were operating a vehicle, so anyone who operates a motor vehicle must have insurance on the vehicle or must provide the officer proof of insurance. So Ohio requires anyone who drives a motor vehicle to be insured and to provide proof of insurance to the officer or to the court if they're cited. So, but that not applicable box that he checked, I was questioning myself why that took place, and I think that's where you were wondering what that word or what that meant.
yeah,
So does that help explain to you what it means?
yeah.
Okay, so there are two charges again: driving under suspension, a first-degree misdemeanor, and use of headlight beams, a minor misdemeanor. With respect to the first charge of driving under suspension, how do you plead?
Not guilty.
And with respect to the other charge of use of headlight beams,
The
how do you
judge
plead?
proceeds to the pleas, and Sullivan responds with two firm not guilty answers. What stands out is her immediate refusal to consider a court-appointed attorney. The judge pauses, trying to understand her reasoning, knowing she's facing a charge that could lead to jail. It's a pivotal moment, revealing her confidence, but also raising concerns about what she may not fully understand.
Headlight beams, how do you plead?
Not guilty.
Okay, the court will accept your not guilty pleas. Are you asking the court to consider appointing an attorney to represent you in this case?
No.
Are you going to retain an attorney?
No.
Are you going to represent yourself?
Yes.
Okay, and can I ask why you do not want an attorney or me to consider appointing an attorney?
Well, the court appointed attorneys, they have too much on their plate, so they don't bother to actually try to fight to, for you. So, and the other attorneys, they just have the court's best interests at heart and not their clients.
So you feel you can represent yourself better than any attorney?
Yeah, because I can represent myself to the best of my ability. It's not that hard to go down to the library and get a bunch of books and look through them.
Okay, I mean,
It's not that hard to ask Google of how to do stuff. I mean, I do know how to argue my case.
okay. Well, the reason I asked this, Ms. Sullivan, is because there is a potential jail consequence on one of these charges. And so anytime there's a potential jail consequence, I do everything, I and any other judge does everything they can to ensure that the person, the defendant, is being represented by an attorney. So again, I'll ask, do you want me to consider appointing an attorney?
No.
Okay, so officer...
Here the judge pushes back, warning her that representing herself with jail on the table is risky. Sullivan explains her distrust of attorneys and insists she can handle the case alone. The judge has no choice but to send her a waiver, making her formally acknowledge that she's choosing to proceed without counsel. It's a decisive moment where the path ahead becomes entirely her own.
Officer, I'm going to take a moment. I'm going to leave the bench, and I'm going to email or have emailed to you a waiver of counsel document that Ms. Sullivan will have to read and sign.
Okay, Your Honor.
So give me 1 second. Okay, the court will note upon that she signed the waiver of counsel document, and the court will note that she's going to represent herself in this proceeding. Okay, I'm now going to set bond. This case is 3 years old. Can you help me understand before I set bond, Ms. Sullivan, why you failed to address this matter for the last 3 years?
Well, Your Honor, I have ADHD. And at the time I received the ticket, I was going to court with my own children. So it slipped my mind, and I had completely forgot about it. I did, however, get North Kingsville taken care of. The original people that suspended my license.
Okay. Where do you live? What's your address? That's the same address on the ticket. So you lived there for a few years, or how long have you lived there?
I've lived there for probably 10, 11 years now.
Okay, I will go ahead and set bond in the amount of $10,000 personal recognizance. I will set this case for a pretrial conference in the near future. You're being released, Ms. Sullivan. We will give you, before your release, a hearing date.
Okay.
You will know before your release today when you have to come back to be here. And if you fail to appear, I'll have to issue another warrant for your arrest. And if that does happen again, then I'll make sure you sit in jail for as long as I can keep you there. So make sure you're here on the date and time that your case is scheduled. Understood?
Yeah.
Understood, ma'am.
Yes.
Okay, this matter is concluded. Thank you.
The hearing wraps with the judge setting a $10,000 personal recognizance bond. Sullivan explains why she ignored the case for years, describing personal struggles and forgetfulness. The judge offers one final warning: miss the next court date, and she'll sit in jail as long as legally possible. It's a firm conclusion to a volatile hearing.